When we are talking about justice and the justice delivery system, especially in India, judiciary is the one-stop solution. We think so. But when we are talking about judicial discretion, it seems like it is against justice, because the recent highlights show the fact that gender justice has come and stood opposite the judicial discretion. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to talk about the fact that how come amongst 510 cases related to dowry death, 508 of them got bail, with similar bail order, with similar documents and everything that seemed mechanical. So, can justice be mechanical, or it needs to have sensitivity, humanization and so much more, which is about the justice delivery system that we think about. And that is exactly what has happened when Supreme Court has finally scrutinized the bail orders, where we find 99.6% dowry death cases have got bail. Let us try to understand all the layers around it, starting with understanding what exactly has happened. So this is the case of Allahabad High Court, where a pattern has emerged, especially in dowry death cases. As I mentioned, out of 510 cases, 508 cases have got bail. That gives the percentage of 99.6%. Now, what is more concerning with the pattern is not just the number. The concerning part is also about that these orders had the same reasoning, they had the same bond amount and they also had almost identical language in the order. So that is why Supreme Court of India intervened and called this pattern shocking. And that is why we get to see that today we are talking about judicial discretion versus gender justice. Because when we are talking about such heinous crimes such as dowry deaths, which are against the spirit of equality, which are against the spirit of humanity itself, they need to be dealt in the extreme order to deliver justice, to create an environment where, yes, the word of judiciary is understood, the spirit of judiciary is understood and it is also feared. But the gender justice that we are trying to get from the framework doesn't seem to be delivered as of now. So for this, let us start with understanding the legal framework, especially around dowry deaths. So when we are talking about the legal framework, dowry death is handled as per section 304B of IPC. Now when we are talking about a case of dowry death, that case is taken up under the given section when the death has happened within 7 years of marriage, the circumstances of death are unnatural, and also when there is presence of evidence of dowry harassment soon before death. That is when this section will be invoked. And when we are talking about a case of dowry death, this is where the accused has the burden of proof. Usually when we are talking about accused, he is innocent until proven guilty, but in this scenario, the court does assume that he is guilty until unless he gives the proof that he is innocent. So there is a reverse burden of proof which is present in the cases of dowry death. And this is directly related to laws such as Dowry Prohibition Act of 1961, section 498A IPC related to cruelty. So the whole idea of this legal framework is to ensure that the systemic patriarchy that exists, that is dealt with, and economic coercion in the name of dowry and patriarchy, that is also dealt with. And that is why this particular legal framework is present there to give the legal protection required, especially to married women. So basically, if we look at it, we get to see that how seriously law deals with dowry death, how seriously it is taken. So legally, this does not seem like an ordinary crime. It is taken as a structural gender violence issue itself. But when we are talking about such heavy words, we are talking about law protecting, legal protection and so much more. What we just saw in terms of number seems to dilute and delete absolutely what. Now when the discussion is around bail, let us also try to understand bail in itself, because when we are talking about bail, the general principle around is that bail is the rule, that one must get bail. If we are giving him the jail, if we are sending him to jail, that should be an exception. And once a person is being considered for bail, it is based on the presumption that he might be innocent. There is also his fundamental right, protection of personal liberty, and that is also involved there. But when we are talking about all of these considerations, the core doctrine, that also does not mean that bail is automatic. There are a lot of considerations that are taken place. For example, the judge will consider that what is the kind of offence, what is the gravity of offence, what is the nature of offence, what are the evidences which are present. Are there any possibility that the accused might run away, he might go absconding? Are there any possibilities that he might witness tamper? And what will be the societal impact if the bail is issued? Now when we go back to dowry death and the number that is present in front of us, we have to definitely look into the fact that it is not possible that when we are talking about 510 cases, for all of these, most of these cases, all of this was on similar consideration. Because if the consideration was not same, then how come the orders were same, how come the bond for bail was same, and the language which is present, that was also same. And especially when we are talking about serious crimes such as dowry death, this scrutiny, this consideration should be higher, not rather reluctant. It should be done with presence of mind. Courts are expected to have higher scrutiny, and this is where the problem comes. If the reasoning is same, and this is where the problem and the controversy comes in. If the reasoning is same in all the cases, it seems like the considerations were absolutely absent, not present at all. Now that we have understood what exactly has happened, let us understand why it is so problematic. What are the core issues around it? Apart from the fact that this is a classic model of mechanical justice, where justice is not considerate, where justice is not humane, and we also get to see that it is pretty much absent-minded, and which is shown by lack of case of specific reasoning, and we see that justice is template-based. It is a copy-paste thing which has been presented. Apart from that, a bigger issue that we should be worried about is judicial discretion. When we are talking about discretion which is given to judiciary, it is one of the highest reason is for their independence. But when discretion is misused, it becomes arbitrariness. And this pattern clearly shows that there was a systemic bias that the judge had, and there was absolutely no scrutiny at all. Furthermore, when we are talking about gender justice again and again, we get to see that dowry death has to be understood as a grave crime. It is not an no crime is ordinary, but if you are placing it, classifying it, this is a heinous crime. In such a situation, if the bail ratio is higher, this will show the public that there is no deterrence at all. They can do whatever they want. And this will also discourage the victims and encourage the people who are doing it. So it is not only about how judiciary is behaving, what is the judicial discretion and the misuse of it, what kind of societal impact this high bail rate will give, it is also absolutely detrimental. And when we top all of this, we have to come to the basic fundamentals of our constitution, that is rule of law. Rule of law means similar cases treated similarly, correct? You will say, then ma'am, this is correct. They have treated the similar cases similarly. But rule of law also means at the same time that each case will be examined independently. So when we are talking about equality before law, it is about consistency, it is about rationality, it is not about blind uniformity. So this is something that brings a question about similarity, because similarity which is here, it is forced, it is copy pasted, it is not reasoned, it is not examined, and that is where in all the places the flaw with this bail rate lies. And when we are talking about this issue that has been brought to attention, which is making to the news, it is not just legal. It has multiple dimensions which we need to think about. Because when we talk about the judicial dimensions, not just the issue, we also need to think that when we are talking about independence of judiciary, what will happen to accountability. Supreme Court has wrapped the Allahabad High Court judge and Allahabad High Court also, but how much Supreme Court will look into? Should there be a mechanism which should review what is going on? And should there be limits on discretion that have been given to the judicial system? Then we also have to look in the societal dimension, because this number, the 510 cases that have been presented in 3 months, show the very fact that we still have dowry system present in our country, alive and kicking. That means putting people to death, putting girls to death, letting them not live to their potential, letting them not live alone at all. Apart from this presence of dowry system is a clear indication that till date, patriarchal family structures exist, and these are one of the core causes of such grave crimes existing in our country. Because when you look at the NCRB data, we still get to 6,000 to 7,000 dowry deaths every year. This is the regular trend that has existed, and you have to keep in mind that the underreporting in this crime is huge. So the actual number is not present in front of us, but the number in front of us is not also something that we can live with. Now when we are talking about dimensions itself, we have to go beyond judiciary and society. We also have to look into the governance aspect, because when we are talking about bail, we get to see that there is absence of clear bail guidelines. So discretion which is present, that has no boundaries at all. Apart from that, the judicial patterns, they have no or limited monitoring which is present. Furthermore, when we are talking about the justice delivery system, or when we have to speak of criminal justice system which is to be dealt by judiciary, we get to see that this criminal justice system is having structural issues as such as overcrowded prisons. Judges might have to give bail because prisons do not have space. So the pro-bail approach is also because of the structure. There is excessive delay in trial. That is why prolonged incarceration is present. And most of all, the ethical dimension. When I say most, unfortunately, this is the least considered dimension. Because when we are talking about justice, I have started with it, it cannot be mechanical. So we talk about judicial empathy, but the problem here is it stands against legal formalism. But this does not allow legal formalism to dilute or delete judicial empathy. Apart from that, the responsibility that the judiciary holds in terms of gender crimes, because this is where justice is needed the most and it lacks the most. And it directly raises questions on the institutional integrity of our judiciary itself. So when we are talking about a situation like this at our hand, it raises a lot of questions. But here we need to know what can be done. So here I ask you, what are your suggestions real time that can actually put up a way forward to make sure that these situations in our country change? Let me know in the comment section. That was all from my side. Thank you so much.